The seller's signature acknowledges receipt of the agency law disclosure at both the listing stage as an addendum to the listing and on presentation of a buyer's offer as an addendum to the purchase agreement. The agency law disclosure is treated by the seller's agent as a preliminary and compulsory listing event. The agency law disclosure is signed by the seller and handed back to the broker or their agent before settling down to finalize the listing to which it will be attached. Remember, if the broker or their agent fails to hand the seller the agency law disclosure at the listing stage, the listing, and thus the agency, can be canceled by the seller at any time. Alternatively, the seller may cancel payment of the fee due to the broker after the transaction is in escrow and the fee has been further agreed to. Thus, all your hard work will be for naught. And what about the buyer's agent? Well, the buyer's agent provides the agency law disclosure to the buyer before they sign any writing that initiates negotiations contemplating a sale or lease transaction for a term greater than 1 year. The law requires a buyer's or tenant's agent provide the disclosure form as soon as practicable prior to the execution of an offer to purchase or lease. Or in other words, as soon as possible. Well, what does this actually mean in application? As a matter of good practice, the disclosure form is provided and signed by the buyer or tenant when entering into a buyer's listing agreement or an exclusive authorization to locate space, because this is the moment affirmative agency duties commence. Also, the agency law disclosure form needs to be attached as a signed addendum to the buyer's purchase agreement offer submitted to the seller. Sometimes your principals are not always cooperative. That happens. What do you do if the seller accepts a purchase agreement or enters into a counteroffer but refuses to sign the disclosure? If the seller refuses to return a signed copy of the agency law disclosure, document the refusal to preserve your right to receive a fee from the seller. As a universal rule of real estate, get it in writing. If someone claims they were never handed the agency law disclosure, written documentation dispels such a claim. The written documentation also preserves your fee.